Okay, I am going to begin. This is the webinar regarding real estate, and we want to mediate, not litigate. And I have two exceptional panelists who have joined me. First, I'd like to introduce Neil Kalin. He is the Assistant General Counsel for California Association of Realtors. He joined the association in 1987. He is now Senior Legal Advisor to Standard Forms Committee, which I assure you is a huge job, and provides advice to CAR Members Legal Hotline. He additionally writes many of the California Association of Realtors appellate court briefs. He's a member of the American Arbitration Association and serves as Judge Pro Tem, has served as Judge Pro Tem, and he's volunteered as a mediator and arbitrator for the Los Angeles Superior Courts. So thank you very much, Neil Kalin, for joining us. Lori Dobrin is a 30-plus year litigator, mediator, and settlement officer. Her work in the various courts include the U.S. District Court and the Superior Courts of Los Angeles, Santa Barbara, and Ventura counties. She is an ARC mediator, which is Alternative Resolution Centers, and has assisted parties in the numerous conflicts regarding landlords and tenants.
Thank you.
And with that, I would like to share my screen, and Neil is going to handle the residential homeowner, and Lori will tackle landlord and tenant.
Great, we see it. If you could put it in presentation mode, that would help. Perfect. Thank you very much. Thank you, Melinda. Good to see you, Lori, and thank you, SCMA, for inviting me to participate in this program. Just a little more history about myself. Melinda mentioned that I am a member of the AAA. What that means is I am an arbitrator for the American Arbitration Association, sort of a side job that I have when I am not busy writing forms for the California Association of Realtors, or writing briefs for the California Association of Realtors, or giving speeches for the California Association of Realtors. Now, many years ago, when I had a lot more hair on my head, or I had hair on my head, I was actually a member of SCMA for several years. And I found out that I personally was not well suited to become a mediator. Being a mediator is hard work. You have to really care about the parties that are in front of you. You have to work with them, whether they are disagreeable or they are agreeable, whether they are cooperative or whether they are uncooperative. And I found that that was not a skill that I particularly had. And so I said, well, I guess while I am interested in mediation and I want to promote mediation, it is not something that I personally want to be. And the reason I'm bringing that up is because I think it's important that if you are a participant in a mediation program and you have a lawyer who is analyzing potential mediators for you, you want to look at them. You want to find out their background. You want to see if they are going to be a good fit for your dispute. And like I say, I personally found that I wasn't a good fit for that role, and I found a different role for me. But I think it's important for anyone out there, whether you are in an attorney role or whether you are in a principal role, that you have the ability to evaluate a potential mediator for your case. You want to be comfortable with the mediator. You want to make sure, if at all possible, that the mediator has some knowledge in the substance of your dispute. And I think that could be very helpful. So let me quickly go through. There's a lot of slides here. I don't need to go through all the slides here. I've got some questions I want to get to. But for those of you who are unfamiliar with mediation, basic question is, what is it? Well, it's not a trial. Like I say, I'm an arbitrator, so I sort of hold sort of trials outside of the court system. That's not what mediation is. Mediation involves parties who have a dispute coming before a third party, a neutral third party, who will help the disputing parties come to a resolution. The mediator may give the mediator's opinion on the case. The mediator may try to extract from the parties what they are truly interested in versus what they are saying they are interested in. There are different models of mediation. I think we're going to get to that in just a few slides, okay? But a mediator does not have the authority to make a decision for the parties to the dispute. The mediator is there to basically facilitate a negotiation between those parties, and a good mediator will help the parties facilitate and hopefully let the parties reach an agreement on their own. Mediation in the context of a real estate dispute, a real estate purchase dispute, is a required first step before either litigating or arbitrating. And in the CAR residential purchase agreement, there's a clause that imposes on the parties an obligation to mediate before they take either of those other litigation steps. And there is penalties if a party fails to mediate. Here we go. So here we're looking at the definition. There are evidence code. This is the California Evidence Code 1115. So you can find that there are definitions. Mediator is much broader than just the individual who might be facilitating the negotiation. It also includes the company that the mediator is working with or working through, as well as other parties that may be contacted in an effort to set up the mediation. Let's go to our next slide, please, Melinda. Okay, so this is what I was talking about before. There are different models of mediation, essentially two broad categories: a facilitative type of mediation and an evaluative type of mediation. And what's the difference? Well, in a classical facilitative type of mediation, the mediator, it says here, while remaining passive, the mediator is never really passive in the course of a mediation, right? So that's probably not a good word. The mediator is not passive, but the mediator will refrain from giving the mediator's opinion as to where the case should go, right? The mediator is trying to facilitate the needs and wants of the parties to the dispute. In a evaluative mediation, the mediator may take a more active role in reminding the parties of what case law may say or what the mediator's experience has been with similar type disputes. Next slide, please. Good examples of some types of, no, go back, please.
Oh, I'm sorry.
Go back, well, that's okay. Some types of words or phrases that you may hear in a more facilitative type of mediation is the mediator will say, you know, what I hear you saying to one party, or how did this make you feel, or what could you do to correct, change, fix, alter the situation? In a more evaluative type of mediation, the mediator may make comments such as, are you aware of this law? Are you aware of this statute? Are you aware of this case? A judge or a jury may not believe what you were saying or may be skeptical of this particular position. Or even, I think, the mediator is giving their opinion. Modern mediation is rarely either completely facilitative or completely evaluative. Modern mediation is usually some combination of the two, but every mediator will tend to lean more towards one side than the other. Next slide, please. So this is the clause in the CAR residential purchase agreement. Paragraph 30 says the parties agree to mediate any dispute or claim arising between them out of this agreement or a resulting transaction before resorting to arbitration or court actions. Now, in the case of the real estate purchase contract, there are exceptions. There are exclusions from the requirement to mediate. And some of those you see right there, excuse me, you see right there in paragraph B below, the exclusions. What are they going to be? Well, if something can be heard in small claims court, or needs to be heard in bankruptcy court, or if there's an unlawful detainer action, that is an exclusion for mediation. Now, parties can mediate those disputes, right? And we have Lori, and Lori's going to talk about mediating, right, landlord-tenant disputes. What I'm
Yes.
saying is, for the purpose of the real estate purchase contract, that is one of the exclusions if there is already an unlawful detainer action. But the parties can voluntarily go and try to mediate their dispute rather than submitting it to a judge or a jury. Okay. Going back up to the top of that page where we see paragraph 30, and we're looking at 30A, couple of things I'll mention. The name of a mediation provider is within the body of the CAR contract, and CAR named as the default provider the CAR Real Estate Mediation Center for Consumers. That's there as a default because we don't want parties to fight and have to go to court to determine who is going to be the mediator for their dispute. But the parties are free to agree on any other mediator or mediation service as long as they mutually agree. We just wanted to prevent a situation where parties signed a purchase contract, they have a dispute, the contract says they have to mediate a dispute, and then they wind up fighting and having to go to court to select a mediator. And that sort of undermines the whole purpose of mediation in the first place. There's another provision there in 30A. It's a little bit more than halfway down. And it is something that CAR instituted over 2 decades ago to try to let the parties know how strongly CAR feels about mediation. And there is a penalty within paragraph 30A for a party who does not mediate before litigating or arbitrating. And they potentially lose their right to attorney's fees, even if they are successful in what turns out to be an eventual lawsuit or arbitration. CAR said, well, we can't really force parties to go to a mediation. Essentially, it is a voluntary process. But we know that if we get parties there, there's a good chance that they will settle, that they will be able to resolve their lives, and that real estate agents who were involved in a purchase transaction can then move on with their lives as well. And so since we can't force parties to go, we said, well, what we can do is we can say, if you don't go, there's going to be a consequence for not going. Let's go to our next slide. And yeah, this is just talks about the attorney's fees. The general rule is that the prevailing party is entitled to attorney's fees, but if you do not mediate first, you can lose that right to attorney's fees. Next slide. You know, why is it so important? Well, the reason it's so important, this is just one case. It's a good example. This is a published case. It's called Lang versus Schilling. The parties were fighting over non-disclosure of a particular event. The event happened to be, I believe that there was a low lake level, okay? They did not mediate first. Lo and behold, there was a judgment. What was the judgment for? What were the amount of damages that the parties wound up fighting over? $13,475. What was the amount of attorney's fees that were involved to get $13,475? Over $113,000, right? So attorney's fees far surpassed the actual amount in dispute. Well, the prevailing party without the mediation clause would say, I won, I'm entitled to my $13,000, and the other side has to pay me the $113,000 that I paid for my attorney. But since in that particular case, the Lang case, the prevailing party did not mediate first, they wound up spending $113,000 to win $13,000. So they won, but essentially they lost $100,000. Why? Because they did not even make an attempt to mediate that dispute first. Now, Might that be an extreme example? Well, Lori will talk more about this, but we hear all the time that attorney's fees are consistently more than the amount in dispute. I threw another case up there. This was a case that I happened to be arbitrating. It was a deposit dispute. It was for a commercial property. It was a sizable deposit, right? Getting close to $1 million. Each side spent over $500,000 on attorney's fees. So imagine what would happen to the prevailing party in that case if they did not mediate first. In order to get $800,000 back, they would have had to spend $500,000. Does that make sense to any of you? You know, hopefully not, which is why CAR and SCMA, right, are such strong proponents of mediation. Next slide. So here's a few slides here. I'm not going to go over them. They're types of disputes that are common in real estate. And the biggest ones really are one party fails to close, either the buyer or seller, or buyers often make claims that the seller failed to make a disclosure to the buyer about a condition of the property. Perfect types of claims that are just ripe for mediation. Next slide. These are just more examples, so we'll go on to the next slide. Okay. What are the biggest obstacles to settlement? And Lori, I think I'm going to let you probably talk more about that, you know, but I like this last one, emotions, emotions, emotions. A big obstacle to settlement. A good mediator will allow the parties to in some way vent and in some way control their emotions so that they can work within those emotions to try to reach a settlement. But again, I'm going to let our mediator talk more about that aspect if that's part of your speech, Lori. Next slide. Deposit disputes. Well, a lot of deposit disputes, right? Party does not sell. Buyer and seller argue over who should be entitled to the deposit. Again, would that matter be covered under the mediation first requirement? Yes, unless it falls within the small claims court. But properties in California are so expensive that a typical deposit is well outside of the maximum limit in small claims court, which this year for individual claimants has been raised to $12,500. But that's a pretty small deposit and something that's not likely to occur. So the small claims exclusion is going to be rarely used in a residential purchase agreement dispute. Next slide. You know, how long is a typical session? I'm going to let Lori address that because they can be a few hours, they could be a few days. It really depends, and Lori, I think, would have a better explanation and expertise in that area. So let's go on next. Yeah.
I'd like to jump in on this one.
Of course.
I personally went through mediation. This happened long before I was a mediator. About 15 years ago, we sold our home, and a year and a half later, we were sued. And we were sued because they opened the walls to remodel and they found mold. Okay. So, you know, a year and a half later is a long time. I don't know what happened. I was an agent, still am, and I put that I painted the walls. Anyway, the session took 16 hours, but it was all evaluative, not facilitative. And I only wish I could have talked to the buyers and heard their perspective of what they saw in the house when they opened the walls. And that for me personally, was really eye-opening in why I think both methods work. But they can be long and arduous, but well worth it. We were sued for $125,000 and we ended up settling for $5.
For how much?
$5.
Okay, so very successful. You were very successful in the mediation. And
yes.
You know, you mentioned that in your example, if I heard you right, to use a mediator's phrase, right? In that the mediator style was more evaluative than facilitative, is that correct?
Correct.
Right. And so it could be that although it worked out very good for you, that mediator may not have been listening to maybe what the parties really needed in that dispute, even though it wound up being very successful for you. I see there is a comment in the chat that there's another style called transformative style, and I don't know enough about that to speak to it. So if Melinda or Laurie want to address that either now or at their appropriate time, that would be okay with me too. So again, there's not one way that works for all parties in every mediation. And I think that is the key takeaway here. And it's important for the mediator to be flexible as well, because if the mediator is primarily an evaluative mediator and is not making progress with the parties, that it may be time for the mediator to use some other techniques other than just pretending the mediator is a judge and I think you're right and I think you're wrong and why don't you do what I say? Well, that mediator is acting more like an arbitrator rather than as a mediator. So the mediator needs to be flexible too, to adapt to the needs of the parties.
I agree.
Okay,
And one
great.
thing I will share, we will answer all questions at the end of the session. So I wanted to mention that. So thank you.
Great,
Next slide.
terrific. So you're absolutely right. Mediation could be short, could be a couple hours. It could go for a full day. Sometimes, a mediation can go more than that. And it's going to be it's going to be dependent upon the particular circumstances. Why don't we go on to our next slide? Yeah, okay, we're going to go on. Skip that. This was more a question. This was from another quote. Are attorneys helpful in mediation, or are attorneys more of a distraction mediation? And if Laurie wants to get into that, I will let her do that. Since I am not a mediator myself, I don't feel qualified to make that call. Okay, next slide.
I'm happy to just jump in on that real quick.
Sure.
In the landlord-tenant realm, there are many times that one side is not represented. And there's an attorney on one side, usually for the landlord, not always. And sometimes I have to kind of assuage or calm down the side who is not represented or self-represented, because maybe the attorney for the landlord has bullied that tenant. And so their feathers are ruffled. And sometimes the first, few minutes or longer of the mediation is just kind of calming them down and letting them know that they can talk to me. It's a safe space. And not that I can protect them, but I can just make sure that they don't have to be exposed to that.
Yeah, that's a great point. And improper parties are often present an obstacle in and of themselves, rather than somebody who has an attorney, either because they don't know what they're in for, or they do not understand the legal ramifications of what has happened before and what might happen going forward.
Exactly. I have a lot to say about that.
Okay. All right. Well, I'm going to get through these, so I give you a chance to do that. Terrific. Let's move on, Melinda. So we'll skip through that. Let's go on. What are some key benefits? Again, this is sort of beginner mediation 101. What are some of the benefits of mediation? Well, the parties decide, right? So they are reaching the resolution themselves rather than having some third party, whether the third party be a judge or a jury or an arbitrator. They have a stake in making the decision. And hopefully, because they have had a stake in making that decision, it is likely to be enforced and to continue to be binding. The parties have a continuing feeling of obligation to whatever agreement there is. Mediation, as a general rule, probably not as expensive as going to court or going to arbitration, right? And if a mediation can resolve a dispute quickly, whether it's in a few hours or a day, that's a lot better than having a multi-day trial. That's a lot better than having months of discovery, which winds up being very expensive. And for many people, that last point is key. mediation is confidential. What's said in the mediation stays in the mediation. That is provided for in California law. Parties can contract around that. In my experience, most people do not want to contract around that. They want the benefit of confidentiality, and they can also feel more comfortable speaking their issues in a mediation, knowing that whatever they speak in the mediation should not be revealed outside of the mediation. All right, let's move on. Well, I love I love this comic strip. You know, I'm guessing in the comic these two people who are talking were probably talking about a divorce. And I like it. It's the one says to the other, Frank's lawyer got the apartment and my lawyer got the 2 cars and the beach house, right? So obviously these parties did not did not mediate the dispute. They litigated their dispute. And who's the winner when you go to litigation, when you go to court, when you go to arbitration? Well, there's always going to be one side that's going to win and one side that's going to lose, but the lawyer's going to get paid regardless, right? Whether you're on the winning side or the losing side. When we're talking about the kind of disputes that we're talking about today, real estate disputes, we're not talking about cases that are taken on contingency. We're talking about cases where the lawyers generally act by getting an hourly fee or getting a retainer. The attorneys are always going to win. The client may win or the client may not win. But in mediation, you are increasing your chances that both parties come away feeling like they achieved some level of victory. So I think that may be all, Melinda, am I right?
That is it on the slides. I do have a few questions that
Okay.
I would like to ask you. If a
Sure.
buyer has some issues with the property, are there any statutes of limitation for time frame when they can either decide they want to mediate, or is there a time frame where it's, you know, it's been 2 years, we're done?
Okay. So there's no statute of limitations for mediation. There are statute of limitations for claims, right? So there's breach of contract claims, there is misrepresentation claims, there's fraud claims, there's non-disclosure claims, but there's no cap on when the parties are excused from the obligation to mediate. Now, when they are in mediation, if it has been several years, one of the issues that's going to come up in the mediation, regardless of the type of mediation that the mediator uses, listen, buyer, you may have waited too long to bring your claim, so your likelihood of success is going to be minimal, regardless of how much money you spend to carry on about that. That, I think, is one of the values of mediation. It allows parties to find out what their potential weaknesses are, and some of those potential weaknesses may be statutes of limitation. But a contractual statute of limitation does not prevent a party from having the obligation to mediate. They're going to mediate first, then they're going to find out what their strengths are, what their weaknesses are, and whether it's whether it will be beneficial for them to try to resolve the dispute through mediation rather than going through a litigation or arbitration.
Okay, and if a buyer is suing, but first going through mediation with a seller, because people always ask me, you know, when you're suing, who's suing who? Well, sellers don't sue the buyers. Sellers don't sue because, you know, they ripped out their landscaping and painted the house purple. They don't care. The house is gone. But a buyer could sue because of a reason, and then they want to include their agents and the inspector and the other agents, you know, everyone in the party. So does mediation include that?
Okay, so in the CAR purchase agreement for residential real property, the mediation agreement is between the parties to the contract. The parties to the contract are the buyer and seller. The contract provides that the real estate licensee, either on the buyer side or the seller side, does not matter, cannot be compelled to mediate without the licensee's consent. Also, the purchase agreement mediation clause does not address outside third parties, lenders, inspectors, appraisers, insurance carriers, right? So any claim that one would have, in your example, and you're absolutely right, buyers are the most likely ones to bring a claim against a seller. What if the buyer thinks, well, geez, the seller did not disclose this to me. My real estate agent should have discovered it, or my inspector should have discovered it. Well, the car contract says you cannot bring in the licensee without the licensee's consent. And since the inspector was never a party to that contract or the mediation clause, you would just have to try to voluntarily get their consent. Now, many real estate licensees can be convinced to join a mediation in the efforts to try to thwart, some future litigation that may result. But that's going to be a case-by-case determination by the licensee or the broker for the licensee at that time.
Okay, I think we discussed everything that I have for now regarding the residential purchase agreement. And now, Lori, let's tackle one of my favorites, landlord tenants.
Well, first of all, Melinda, I want to thank you so much for this opportunity, and to the SCMA. It's such a pleasure, and I appreciate the SCMA's support of me during this Mediation Awareness Week and every day of the year. And thank you to Neil for sharing your lunch hour with us, and to all the participants for taking time out of your busy days to share your lunchtime with us as well. So thanks so much. Great to be here. And so the goal is to reach an agreement, yes. And that is a very clever little quip. The question, we have an agreement in principle. The question is, do we have all the same principles? Well, as the mediator, I try to tell both sides how the process works. When I am doing landlord-tenant mediations, a lot of times it is in a court setting. So it's not like the kind of mediations that Neil was talking about, because we don't have as much time. So in landlord-tenant settings, it's important to have a mediator who really is skilled and has a lot of familiarity in that area of law, because you need to really be efficient, but at the same time, you want to make the parties feel like they have been heard and telling their positions. But a lot of times, we don't have a lot of time to mediate, because if we don't mediate within a couple of hours, the court wants to have the trial. So it's kind of a delicate balance. So to get to the same principles, it takes some skill and a lot of diplomacy and patience. Next slide, please. So I think Neil touched upon this a little bit. Some leases do provide that mediation is an option. I find that a lot of times the landlords and tenants don't even read that. They don't realize that sometimes that needs to be done first as a condition precedent. A lot of times the courts will order the parties to mediation or some kind of settlement conference. It's not usually something that they agree to before the litigation. Usually a landlord wants a tenant out for whatever reason, whether it's a failure to pay rent or there's a nuisance or some other reason. And so they, unlawful detainer actions are summary proceedings. They want to be over quickly. They are given priority in court. So the parties aren't going to spend a lot of time. Well, let's mediate this beforehand. They want this done quickly. So mediation usually comes in once the lawsuit is filed. Next slide, please. I think we've kind of gone over the mediation definitions and the evidence code and confidentiality. So we can move to the next. And I think Neil also touched on this. I find excuse me, with the landlord-tenant cases, like I said, there are many times at least one side is self-represented, sometimes both sides. So the parties, they don't know what they don't know. And it's really kind of challenging when I am looking at both sides of the case, and maybe a landlord is really angry because the tenant hasn't paid the rent. And what if this landlord is representing themselves and their notice overstates the rent? Unlawful detainer actions are all statutory. There's not a lot of gray area. It's very cut and dried. If the landlord overstates the rent by a penny, their notice is fatal and a judge could throw it out. So as a mediator, if I see that, I'm certainly not going to say right away, you're going to lose, you're going to be out of here before it even starts. I can't say that. So I have to kind of couch it and deliver the news in a more delicate fashion. And I actually did an article about that in the Daily Journal that came out last month. If anybody's interested in me forwarding it to them, happy to just reach out to me. Melinda could put my email in the chat or just reach out to me. I'm easy to find. So in a situation like that, mediation really is helpful, because if I can talk to the parties and ultimately maybe, the tenant hasn't paid the rent, but really just wants to move on, and move out somewhere, we could maybe come to a solution or a settlement where the landlord's not going to have to refile, because that's what's going to happen. If it gets thrown out of court, the landlord just has to refile, and they're just delaying the inevitable. They'll refile their unlawful detainer and the tenant will be out later. So that gives a little bit of leverage where I can tell the landlord that in my experience, I have seen judges may view your incorrect or inaccurate number as a reason for the tenant to win, or I'll try to say it delicately. So that enables the parties to kind of say, okay, well, maybe I will ask for less rent, from the tenant, and give the tenant a little more time. So that's ways that we try to resolve the case. So like Melinda indicated, it can be expensive for all parties if you just proceed to trial, because there's going to be a winner and a loser. A judge doesn't want to hear about how it's difficult for a tenant to move or whatever unpleasantries transpire between the parties. Next slide.
Melinda, can I jump in for just a moment?
Please.
And what you just said to me emphasizes why there is value when you select a mediator. If you select somebody who's knowledgeable in the field that the mediation is going to cover. It's not necessary for a mediator to have that knowledge, but if a mediator does have that knowledge, a mediator has an additional tool that a mediator can use when working with both sides to the transaction. I think you gave a good example of that.
I also want to chime in that from the landlord-tenant cases I've done, it's just more emotional. You're talking about where they live, where their family lives. It's not like your mechanic who didn't do your car right. So there are a lot more emotions involved, and you really have to take that into consideration.
Yes, tenants sometimes take it very personally. Like you said, it's somebody's home. Even if it's a rental, it's their home. Maybe they've lived there for many years. And by the same token, a landlord, it's business. They have a mortgage and they can't understand how somebody is not paying the rent. Most of the cases, I would say the predominant, it's basically non-payment of rent situations. Of course, there could be some habitability defenses there, but again, tenants don't always realize that what is deemed uninhabitable is statutory, And it's not just, okay, you know, my faucet's a little leaky, my toilet's not flushing. It really has to be something much more significant and substantial for it to rise to the level of habitability. So next slide.
I just like this one.
Yeah, yeah, and you know, to that point, usually the plaintiff goes first. I usually say, okay, you know, since you filed the lawsuit, you know, what do you want out of it? And it's usually pretty clear that it's, you know, they want the tenant to pay the rent and they want the tenant out. And so I have to then go to the tenants and kind of propose that in a gentler fashion, because they take it personally. You know, why would you want me out? That seems so horrible. But so it's a dance. Is mediation legally binding? Well, mediation is a voluntary process. So if the parties don't agree and they can't settle it, they will go to trial. However, if they do agree in mediation or in a settlement conference, in my experience, usually it's right before the trial. So once the case is settled, or you know, through mediation or through a mandatory settlement conference, which is the way many courts handle their unlawful detainer calendars, they order the parties to go to a settlement conference. So it's almost like mandatory mediation, so to speak. Settlement conferences are a little different than mediations. They're not confidential per se, but if we do reach a settlement in either mediation or a settlement conference, we then go before the court and the parties will recite the terms of the agreement to the judge, and the judge makes it legally binding by incorporating it into a stipulation for judgment, where the court retains jurisdiction to enforce the terms of the agreement. You know, I like the parties to be able to recite the terms themselves. Usually there is a competent attorney on one side that can do that, but I always like to monitor just to make sure that everything is articulated the way it was agreed upon in the mediation, because sometimes that doesn't happen. So I just like to be there to make sure nothing unravels. And once it's before the judge and the judge kind of gives their blessing, then it is legally binding. Next slide. So I think we kind of touched on the benefits. It gives the parties agency over their own destiny. And it also gives them some certainty as to the outcome. If the parties would go to trial on an unlawful detainer, and if the landlord prevailed on all of their claims, a tenant could be out in as little as 12 to 14 days once there's a judgment and the writs of possession have been issued and the lockout. If we can resolve it, and even if the tenant has to be out, but at least they have a date certain, so they know and they can prepare. It's not like they're getting a knock on the door from the sheriff with the 5-day notice, you're being locked out. That's very stressful. So there's a real benefit to a tenant to know when, you know, how much time they have, and likewise for a landlord to know that. And sometimes I always like to suggest to the parties that they put in terms that, you know, that the property is to be left in broom swept condition. You know, if there's any breaches of what the agreement is, you know, the thing could unravel. So there has to be some consequences kind of built in if people don't comply. And like we talked about, the emotional costs go down, the uncertainty. I like to tell the parties, you know, what would life be like to put this behind you? and to start a new chapter. It's obviously been really unpleasant living in this property with the way the landlord's been treating you or the way the tenant has been behaving. Let's try to resolve this so we can be done with it. So I think that's one of the best benefits. It really kind of reduces the stress, the anxiety, the uncertainty of how a judge is going to rule, and it's just kind of a win-win. Next slide. So I think, Melinda, you've pretty much laid out what's required in the lease agreement. I can't think of anything else. Like we talked about, sometimes they mention mediation in the lease, but typically I haven't really seen that. And if it's in there, nobody is really looking at it.
I've had cases where people write, they look online and then they write their own lease.
Mm-hmm.
And I will say, okay, so what are the early termination penalties? Well, that was never touched on.
Right.
So I thought this was just an important reminder that if anyone wants to be creative, don't be.
Right. And I've also mediated many cases where there was no written lease. It's a verbal agreement that's very loose, and there's increases in rent and there's not really anything in writing. So sometimes it takes a while to really figure out like how much the rent was and what was being asked for. So that sometimes that can affect how I try to get the parties to resolve, because if there's a verbal lease, that could weaken one side's case. Okay, security deposits. So usually that is a subject for a small claims action once a tenant is out of the property. And it could have been, as a result of an eviction case where the tenant is out and then they are suing the landlord for their return of the security deposit. So I would recommend everybody look up the laws on security deposit, but Melinda, you've laid it out very well here. And also to know that the laws as of April 1st are changing with respect to security deposits when a lease is initially negotiated.
I will also get a lot of the cases that I do that I would say 50% are about the security deposit.
Mm-hmm. Right.
So I do like this slide specifically because I don't think tenants are aware that they can ask for a pre-walkthrough before they move out, which gives them and the landlord the opportunity to discuss anything that they may think may put their security deposit at risk.
Right. And I think that's a great point. And my understanding is in unlawful detainer cases, the landlord does not have to ask for the tell the tenant that they have a right to the pre-inspection, because when it's based upon an eviction, I don't think that applies.
Yeah, I agree with you.
Okay, this is.
Now, I'm just going to chime in. For the cases that I've had, it says after a tenant moves out, a landlord has 21 days. Okay, I'll have people come in and it's 21 days and 5 minutes. So I try and work with them that if the intent is there and they're discussing it with the landlord, sort of hold off, but I'll let you take it.
Yeah, I have not mediated these as much. I've sat as a small claims judge on these kinds of cases, and a lot of times the tenant wants to get the the treble damages, but you really have to show some bad faith on the part of the landlord in withholding. So, next slide. So tenants need to be aware that the landlord can deduct only for beyond ordinary wear and tear. Sometimes they don't realize that. And also what I found, some situations where if it's specific in the lease as to things that a tenant needs to do before they move out, like if it says that they need to get their carpets professionally cleaned, but then they decide they don't want to really pay that, they'll, you know, do it themselves and maybe rent the machine, then they may not understand why they're not getting back what they thought they're going to get back, and the lease provides otherwise. It wasn't professional. It wasn't professionally done. So it's important to really drill into what the lease says about how to leave the property when they move out to avoid these kind of conflicts. That's pretty self-explanatory. Yes, I would agree. If a landlord doesn't return the security deposit, try to work it out first and have it in writing. Don't just say, well, I talked to them and, you know, they didn't respond. Because if you're going to be going into small claims and then meeting with a mediator, you want to have as they call it, the receipts. You want it in writing. You want to have all of your invoices, and it is usually a small claims action. It sounds like, Melinda, you've done a lot of those. I'm usually at the point where they're fighting about, you know, whether the tenant could stay in the unit. This is kind of after the fact.
Well, and you brought up something very interesting when you said receipt, because it's all for landlord tenant. From my perspective, most of it is receipt driven.
Mm-hmm.
If they just say, you know, they don't answer my calls or they don't respond, you cannot tag money onto that. Sorry,
Right.
but they just can't.
Right, exactly.
And this is what you noted.
Right, about the new security deposit limits. Is it effective July 1st? I thought it was April 1st, but maybe you're correct.
July
No,
1st.
April 1st is another one I'm going to touch on.
Okay. Okay. So, yeah, security deposit limits are going to change, and that's more beneficial to tenants. A lot of the newer laws that are going to be in effect April 1st and July 1st are really very protective of tenants, much more so. Okay. And that's a continuation of the security deposit about how you would define a small landlord. And
I do like on this one that, and excuse me for interrupting, that
Yeah.
no matter what, a member of the service only has to pay 1 month.
yes,
Like the fact that we give back to them.
exactly.
And then this is from one of my favorite presidents.
Love it. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. Like that.
Okay, and I'm now going to, let me see, there were 2 questions.
Right.
Okay, Lori, in your experience, approximately what percentage of landlord tenant cases are settled in mediation?
I would say probably around 90%.
Oh, impressive.
And
Lori, can I
Yes.
ask, do you find that there might be a difference depending on whether it is a court-ordered mediation or whether it is a security deposit dispute or a possession dispute?
the court-ordered mediation ones, I would say, is more than 90%. The security deposit, I have not done as many as Melinda, and most of those do resolve. You know, I think, again, it's a matter of kind of managing the people's expectations, calming them down, making them understand what the law is. You know, we all know in small claims, there's no attorneys. So we do have to gently guide them on as to what the law is. And when they realize that and the risk that they might run if they go in front of the small claims judge, that's an incentive for them to settle it.
I would like to chime in that in small claims, when landlord and tenants go in front of the judge, make sure you have all your documentation. I agree. I've seen more disappointment over handshakes than anything else. And we're sort of short on time, so I did want to mention April 1st is the day that they will start with the Tenant Protection Act. And lots of things will change. So if you are a landlord or a tenant or represent them, I advise you to pull it up and read it. Lots of change coming down the pike. And my last comment, which I see as an agent, is about rent control. The County of Los Angeles has many different cities, and not each city has rent control. Burbank, not rent control. Los Angeles, rent control. West Hollywood, rent control. And a lot of it depends on if the city has its own city council, like Calabasas, non-rent control. So all these things people have to be aware and investigate before they make assumptions, because they could be costly. So let me see. Someone said, what would determine a court-ordered mediation? Lori, do you want to take that one?
Sure. So it really kind of depends on what county your lawsuit is pending in, or your property is. So to give an example, Santa Barbara has a fantastic mandatory settlement conference program. So it's not a mediation per se, but it is court ordered. It's mandatory. So how it works there is any of the cases that have a trial date scheduled, they first come to court on a specific day, and it's the mandatory settlement conference day. And there are volunteer settlement officers. There's one officer for each case, and the parties need to appear. It's all via Zoom, and it works really well. And we conduct the mandatory settlement conference. We have 3 hours to do so. And then we report to the judge whether we have a settlement or not at the end of the day. And if we settle it, great. The judge reads it into the record, makes it into a judgment. They're done. They don't have to go to trial. If they don't settle it, then they report back the week later to go to trial. So not every county has that. I think it's a great program. I wish other counties would adopt it, but that's pretty much, that would be the only court-ordered mediation in a UD setting.
I have 12:59. Do I have any more questions? Otherwise, I'm going to let my terrific panelists go for the end of the day and have a great weekend. Lori, did you by any chance, do you want to put your email in the chat so if people want that article?
Sure. And I can, if people are still on, great. You know, it sounds like, you know, landlord tenant, it's like nobody's thrilled with it. It's kind of a unpleasant thing. So I do have kind of a feel-good story for whoever is still on. And it actually was exactly a year ago, because here we are with March Madness and the brackets. So this kind of has to do with a landlord who was renting to some college athletes that were starters on the men's basketball team. And, you know, both the attorney, there was an attorney for the landlord. The athletes there were 3 of them, they were representing themselves. And probably because they were so busy with practice and their classes and all their other stuff, they were seniors, they had a leaky toilet and probably spaced out in paying their rent, thought maybe because there was a leak, they didn't have to. So here they are in, you know, UD court as defendants. So I was tasked to resolve that case. And, you know, after speaking to both sides and having a landlord that was really open-minded, he agreed to let them get current, pay their arrears, stay in the apartment through the end of basketball season and graduation, so that they didn't have to find another place to live, and they could, you know, focus on their game, their season, their academics. And so fast forward a few months after that, I saw that the team made it to the March Madness bracket, and I still had their numbers in my phone. And so I texted them to congratulate them, how excited I was for it. And, you know, I figured, oh God, they're busy, I'm never going to hear from them. Within like 10 seconds, I get a text back saying, thank you, we couldn't have done it without you. And that's why we mediate. That's why I am so passionate about it, for that kind of response. That made it all worthwhile.
And that's a fabulous story. I'm just seeing one thing in the chats. Tom Stringer says my question hasn't been answered. Okay, and this must be it. Lori, are the court-ordered landlord-tenant mediations you do on a volunteer basis for the mediator?
Thanks for the question, Tom. Yes, they are. That's kind of my way of giving back to the courts, and it is really appreciated by the judges because, as you can imagine, especially after the pandemic, there's such a backlog of cases, and to be able to take a few cases off the judge's docket so they don't have to try the case, it's really appreciated. So I do a lot of volunteer mediations in the UD space.
Okay, my last one says, I didn't see your email address, Lori, pop up.
It's in there to the host and the panelists. It's my name at gmail.com. So Lori Dobrin at gmail.com.
Okay. All right, I am going to, if I'm on SCMA, if you have any other questions, find me. I am going to let our generous panelists off, and I can't thank you guys enough. You were so helpful, informative, and I hope all the participants got a lot out of real estate mediation, not litigation.
Thanks, Melinda.
Thanks, friends.